Thank you so much, Emily, and thank you so much for all the work you've been doing behind the scenes. Good evening, everyone, and welcome to the Young Lawyers Making Change Festival. My name is Adam, and I'm a member of the Young Legal Aid Lawyers National Committee. And I'm really happy to see that so many people are joining us today for our panel, which is entitled Revenge or Reform, a critical appraisal of the government's Constitution, Democracy and Rights Commission. And in just one moment, I'll introduce you all to our panel of speakers and to the theme of tonight's panel. But first of all, and for those of you especially who weren't able to attend yesterday's opening keynote, I want to give a brief introduction to the festival and to our organisers and sponsors. So by way of background, this is our third year of the Young Lawyers Making Change, the Fight for Social Justice conference, but it is the very first time we're holding it virtually. And the aim of this conference is to educate and inspire social welfare lawyers of the future and to enable them to build a network of like-minded junior lawyers who are committed to working in areas of law which have been traditionally funded by legal aid. The conference/festival is a collaboration between the Public Law Project, the Justice First Fellowship and Young Legal Aid Lawyers. And we're also really grateful to the Legal Education Foundation, or the LEF, for sponsoring it and helping us to make this happen. The Public Law Project, for those who aren't already aware, is a fantastic legal charity which aims to improve access to public law remedies through research and strategic litigation. And as I mentioned earlier before, we're really helpful to Amelie Godfrey, the PLP's Events and Communications Officer, who's doing a huge amount of work behind the scenes to really make sure the show keeps going. The Justice First Fellowship was established by the Legal Education Foundation to support the next generation of students who want to pursue a career in social welfare law. And each year it teams up with a variety of firms and chambers to create placements for individuals to train to become solicitors and barristers. No pupilages are on offer this year, but there are a record number of 19 training contracts available. And the window for 2021 applications opens on the 17th of August, so if you'd be interested in applying to become a Justice First Fellow, please do make sure you have a look at the JFF website and put your application in accordingly. Finally, Young Legal Aid Lawyers, YLAL, was founded 15 years ago and exists to represent the voice of junior lawyers committed to practicing in areas of law, both criminal and civil, which have been traditionally publicly funded. We campaign for a sustainable legal aid system which provides good quality legal help to those who could not otherwise afford it. And we also campaign to increase social mobility and diversity within the sector and to promote the interests of junior lawyers within the legal aid profession. You can join YLAL completely for free on our website. Just go to younglegalaidlawyers.org. I'll copy and paste that in the chat for anyone who's interested. And please do also check out the website to find out what's happening over the next 2 weeks of the festival. We've got events on most evenings of the week, and we've got loads more great speakers on a variety of topics to hear from. And this Friday, we'll also be hosting a legal aid quiz for which there will be a cash prize. So, turning to our speakers and the theme of tonight's panel, in the 2019 Conservative Party manifesto made a number of claims, among which were that to protect our democracy, the UK's constitution would have to evolve in order to restore public trust. The manifesto spoke of the purported need to recalibrate the quote-unquote balance of rights, rules and entitlements that benefits all the people and all the parts of our United Kingdom. The manifesto promised that within its first year, the government would set up a Constitution, Democracy and Rights Commission. It's now August. There is no such commission. Doesn't look likely that there will actually be one set up anytime soon. But the government has already taken steps to set the rhetorical scene for constitutional reform. Suella Braverman, the Attorney General, has previously spoken of the need for politicians to take back control, whatever that might mean, from the judiciary. Beyond the rhetoric, the government is taking concrete steps to press forward with its constitutional reform agenda. For example, the government have recently set up an independent review into judicial review. And throughout the course of the coronavirus crisis, tensions have arisen as a result of the divergent approaches to coronavirus adopted by the UK government and the devolved administrations in Scotland, Wales and Northern Ireland. So, even in the absence of any commission, I think we have plenty to discuss tonight, which leads me to introduce our speakers. We're joined today by Professor Alison Young, the Sir David Williams Professor of Public Law at the University of Cambridge. And among her numerous other responsibilities, she currently co-edits the UK CLA blog on constitutional law and is also a member of the editorial board of European Public Law and of Public Law. She is also a fellow of the Higher Education Academy and a trustee of the Constitution Society. We're also joined by Professor Meg Russell. Meg Russell is the Professor of British and Comparative Politics and Director of the Constitution Unit at UCL. She leads the unit's research work on Parliament and is currently a Senior Fellow with the ESRC-funded UK in a Changing Europe programme. She is particularly well known for her work on the British House of Lords, bicameralism and parliamentary policy influence, among an array of other areas. We're also joined by Michael Alatokun. Michael is a Research Fellow in Citizenship and the Rule of Law, and he is also Head of Public and Youth Engagement at the Bingham Centre for the Rule of Law. Before joining the Bingham Centre, Michael worked as a political organiser, encouraging young people and disenfranchised groups to participate in public life. Finally, and kicking us off today, we are joined by Dr. Sam Fowles, a barrister at Cornerstone Barristers, thank you for the wave, and a fellow at the Foreign Policy Centre, where he specialises in information governance, data protection, environmental law, policy, trade and investment, constitutional law, and Brexit. Now, the order of the day is that each speaker will speak for between 10 to 15 minutes. Amelie has kindly agreed to provide a 2-minute warning to our speakers. And after we have completed our speaker contributions, I will put questions to the panel. So please, in the course of the talk, please do put your questions into the chat box and I will read them out when we get to the Q&A. So without further ado, I will hand over to Sam, who will start us off today. Sam.
Good evening. Doesn't really feel like evening. It's still bright sunshine, but good evening nonetheless. I've been asked to talk about or focus on the topic of political judicial reviews, and you'll see why I use the very ironic air quotes in a moment. Obviously, I'm a practitioner in on a panel of academics, and so every other panelist will have a much more nuanced version of the sort of meta view of this than I will. And so I intend to leave that to them. What I propose to do is talk about 4 cases. And these are 4 cases in which I've been counsel in some capacity, whether as leading them myself or as junior counsel. 2 of these cases went to court. 2 of these cases didn't, and you'll see why why that's significant as we move on. And as I tell you about these cases, I'd like you to be aware of 3 overarching points. And the first of these is that every single decision that a court makes is to some extent political, because a court is imposing a set of norms and values on those it regulates. However, the second point is that political is a very unhelpful word because it can effectively mean anything. What courts do not do is interfere with the making of public policy or go beyond the law. And third is that we are perhaps departing from the rule in that second point now, not in the way the government is suggesting by courts becoming more activist, but in fact the opposite, and through a campaign of intimidation, effectively. Certainly, were I presenting this, seeking an injunction for harassment or something, I would describe what the government have done to judges as a campaign of intimidation. Because of that, judges are doing the opposite of interfering in politics and actually refraining from making decisions, enforcing legal rights that they are perfectly entitled to make for fear of being seen as interfering in politics. Now, as I say, these are things that come out of my own cases. I don't pretend that they have any sort of macro value, and if they do not, I do hope I will be corrected by those with a better view. So, turning to the first case, which is the Miller-Cherry case, often called the prorogation case. Now, the facts of this will hopefully be relatively familiar. I was chatting to Alison just before, and they are depressingly familiar. I think she probably described them as. But just in case they are not, the bare bones is that in August last year, 2019, the government indicated that it would prorogue Parliament in September. And this was not an idea that came out of the blue. It was an idea that had been kicked around since, I think that I first saw it being kicked around in January 2019. And the idea was to prorogue Parliament in order to prevent Parliament from interfering with Brexit negotiations. Now, of course, the government didn't say we're going to prorogue Parliament to prevent it from interfering with our negotiations, but as not just the Supreme Court, but also the Scottish Court of Appeal, called the Inner House of the Court of Session, found that was the objective effect of the government's decision. Now, initially, the government, in fact, refused to provide the reasons for its decision to prorogue, but the Court of Session asked it to do so, and it provided a single letter that later became known as the Gurley-Swat Memo, due to Boris Johnson's annotations in the side, which were incidentally initially redacted because they were supposedly sensitive. So that was the first misleading thing that the government's lawyers said to the courts. It was not the only one. But this memo didn't indicate any particular reasons. It merely expressed the opinion that the government's decision was lawful. Now, two challenges were brought for this, one by Gina Miller, and that was brought in the English courts, led by Lord Pannick and the team that won the first Miller case. The other was brought by Joanna Cherry, QC MP, and 73 other parliamentarians, and that's the one on which I worked, and that was brought in the Scottish courts. Now, both the Scottish High Court, which is called the Outer House, and the English High Court found that the matter was non-justiciable because it was a matter of high politics. The Inner House of the Court of Session, however, which is effectively the Scottish Court of Appeal, found that the matter was justiciable, and it did so relying on an earlier Scottish case called Whiteman. And I'll read you out a quote from Whiteman here. The fundamental purpose of the supervisory jurisdiction is, in my opinion, to ensure that all government, whether at national or local level, and all actions by public authorities are carried out in accordance with the law. That purpose is fundamental to the rule of law. Consequently, I would have no hesitation in rejecting any arguments based on procedural niceties or the detailed scope of previous descriptions of the supervisory jurisdiction. In reliance on Whiteman and a number of other cases, the Outer House found that the matter was justiciable and found that on the facts, the government had provided a misleading description of its intention, which was, and the real intention was to prevent Parliament interfering in the Brexit process. We then all trooped up to the Supreme Court, as we inevitably knew we would. The Supreme Court decided in accordance with the Inner House, but not for the same reason. The Supreme Court found that it was unlawful because it had the objective effect of preventing Parliament in having a say on a matter of overwhelming constitutional importance. And it did so without a proper reason for doing so. Now, the question of a proper reason for doing so has been criticised, not least by John Finnis in a paper with a remarkable absence of any authority cited in it. He suggests that this is a very difficult concept. In fact, it was never really argued before any of the courts that there was any other effect that the decision to prorogue had, and it was not, and the government never really produced any evidence for what they said the real justification was. So The Supreme Court's decision there was really based on an absence of a positive case put forward by the government rather than anything else. Now, the Supreme Court in Miller was accused of changing the Constitution or creating a new rule. And probably you could go into that in great detail in a sort of black letter context, which we don't have time to do now. But suffice it to say this, before the Court of Session, we set out a review of the case law and authority going back to Robert the Bruce, which I believe certain people had to read. Before the Supreme Court, the authorities bundle was so large that I had to have it sent over from my chambers in an Uber because it was too big for any clerks to carry. The Supreme Court's decision was based on extensive authority going back hundreds and perhaps even 1,000 years. And it relied on two principles, and those are the principles of parliamentary sovereignty and parliamentary accountability. And it seemed to me obvious from the very start, and this is why I never really had doubt about the outcome of this case, that if the government could prorogue Parliament with the effect of silencing Parliament, of excluding Parliament from a decision, then that must run contrary to those two principles. And that was what the Supreme Court decided. The second case, and this is the second case that went to court and was decided, was a case called Vince and the Lord Advocate. And this was brought by a businessman called Dale Vince. And it was for an injunction to enforce what became known as the Benn Act. And the Benn Act was an act of Parliament passed which required the government, if by the end of October 2019, a withdrawal agreement had not been settled, to seek an extension to the Brexit deadline from the European Union. So let's be clear about the legal effect of this. It was I think, a 3-clause bill. It was very, very simple. It was a direct instruction passed as an act of Parliament, from Parliament to the executive to do something. Now, I went through the evidence for this morning again, and on 43 occasions between the passing of the bill and the 31st of October, the Prime Minister or a representative of the government said that the UK would leave the EU on the 31st of October, regardless of whether a withdrawal agreement was settled. Obviously, doing this would have been in contravention of the Act and therefore unlawful. But challenging it after the fact was obviously pretty pointless, because by operation of Article 50, the UK would have already left the EU. So we sought, and this was the same team basically that represented Joanna Cherry, we sought an injunction from the Scottish courts to force the government to comply with the Act. Now, the inner house of the Court of Session said no. The outer house of the Court of Session said no, but the inner house, something quite interesting happened, which was that the government's lawyers stood up and said, oh, guys, we were only joking on those 43 occasions that we said we weren't going to comply with this law. Actually, we are. And the inner house said, well, okay, but you've said 43 times that you weren't, so I don't really believe you. So it did something unprecedented, which said, we're going to effectively stay in session on this matter until you comply with the Act. And as we all know, the government did, with exceptional bad grace. That's the second case. On to the two cases that didn't happen. The first was going to be the Bureau of Investigative Journalists against the Prime Minister, and this was seeking the disclosure of the Russia report back in November 2019. Now, this case ended because the witness that we had that said there was no issue of national security at stake ultimately dropped out. However, the Russia report was later disclosed, as we all know, in, as I understand it, the same form that it was going to be disclosed in autumn 2019, and there were no national security implications. And what this demonstrates is effectively national security is a shibboleth, that central government can say these two magic words and the courts will rule in their favour. It is, amongst practicing lawyers, notoriously difficult to get round a national security argument, and it's rarely ever happened. But the point is, the government doesn't even have to prove its case when it comes to national security. It just has to say it, even as in the case of the Russia report, when it was patently not true. The second case that didn't happen was an MP, whose name I can't disclose, against the leader of the House of Commons. And this case concerned the decision of the leader of the House a few months ago in May to hold a vote on whether to on how to continue parliamentary business in the pandemic while requiring MPs to attend Parliament effectively. And the problematic thing was that the leader of the House decided to have this vote after the measures that allowed parliamentarians to attend remotely had all expired. So the substantive effect of the leader of the House's decision was to exclude, I think, about 200 MPs, which is about a third of well, not quite a third, but nearly a third of the total, from a decision about how Parliament would continue. Now, this would have been quite a controversial case because of something called Article 9 of the Bill of Rights, which requires that the courts will not interfere in the business of Parliament. But what we said was this was not interfering in the business of Parliament. This is a decision that's been taken by the executive and that reached in to Parliament. In the end, it was never settled. And the reason it was never settled is because I and my colleagues advised our clients that we couldn't go ahead, not because we didn't think we had an arguable case, but because we thought that no judge would rule in our favour because they would be too scared to upset the status quo.
2-minute warning.
Thank you very much, because that brings me to going back to these three concluding points. The first, decisions of the courts are to an extent always political. I did a planning inquiry a few weeks ago, and it was an enforcement inquiry, and in very glamorous circumstances, we forced a chap to remove his caravan from another chap's field. It was based on a government policy which said that essentially that caravan sited in that field was not appropriate, and in a planning sense. It was a policy with which the other side disagreed, but they of course had no choice, and the courts enforced the existing government policy. This was political. This was enforcing one set of norms against another set of norms. It's no different in the case of Cherry, where you enforce one set of norms, that parliamentary sovereignty and parliamentary accountability should not be curtailed against another set of norms which says, well, the executive should be allowed to do this when it's convenient because it allows the executive to govern conveniently. These are both political decisions, but they are both enforcing existing law, because that's what the law does. Second, the courts don't interfere with public policy. In the two decisions that I described that happen, Cherry and Vince, these are described as archetypal, the courts making a political decision. In both cases, the courts did one thing, which was to say, Parliament has a democratic mandate. Parliament must be respected. Executive, you must do what Parliament tells you. And finally, are we going away from that? Yes, but in the wrong direction. In the direction of judges being, there being an increasing feeling amongst public law practitioners that judges are unwilling to enforce rights in politically controversial situations. And that is wrong, because we're not in those politically controversial situations. Judges are not being asked to interfere with politics. They're being asked to enforce a right which may have some sort of political implication, but that's not the court's problem. The court's problem is to enforce the law, and because of the government's rhetoric, my experience is the courts are more reluctant to do that. And that's me.
Thank you so much, Sam, for that really informative insight into a practitioner perspective on these issues. I'm now going to hand over to our second speaker, Professor Alison Young, who's going to lead us into the next contribution. Alison.
Thanks, Adam, and thanks also, Sam. You've made my job a lot easier, so thank you very much. So I very much want to pick up on where Sam has left us and to add in by talking about this bigger perspective about how do we distinguish between law and politics, because this seems to be the main theme. The suggestion is that judicial review has become too political, that courts are straying from the proper legal confines of their powers and straying into taking political decisions. So this raises a whole sort of difficult issues, and I would love to be able in 10 to 15 minutes to give you a very clear 3-point account of how we distinguish between law and politics. I can't. So the best I can do instead is to try and take as my springboard for discussion 3 things that was being said when they introduced the new panel on judicial review. So that's the independent panel that's going to be looking into how we reform judicial review. And we have kind of like 2 do's, so 2 things they want, and 2 things they want the courts not to do. It's a big 1 do not. So we do want to ensure, says the manifesto and the Lord Chancellor introducing the panel, that judicial review reforms continue to protect the rights of individuals from an overriding state. That sounds like a good aim. Yes, we're all there for ensuring that individual rights are protected from an overriding state. But we do not want judicial review to be abused to conduct politics by other means, which then raises this thorny issue of how do we delineate between protecting rights and not straying into politics. And finally, my 3rd do comes from Lord Fawkes, the chair of the panel, who said he also, when introducing the independent panel, said we also want to preserve the elected government's right to govern. And this is where the nub comes in about how we delineate between law and politics. How far is this distinction between law and politics about ensuring that courts stay out of taking political policy decisions? And how far is it about making sure courts don't stop the government from getting on with what the government wants to do? And how do we delineate between these different elements? So I want to try and explore this a little bit further to see what we can try and understand from this about how we delineate between law and politics. And I'm not necessarily going to give you a distinction. I'm going to explore these issues to try and raise some of the things I think we need to think about when we see the review panel going through and we try and make this distinction. And if there's a take-home line, it's this is not an easy distinction. There are no quick, fix, easy answers. It'd be lovely if there were. They're not. It is complicated. It's not something you can resolve by simply saying, stay away from politics, but keep protecting individual rights. It's much more complex. So the first thing I want to look at is what do we mean by protecting the rights of individuals from an overriding state? It sounds like a good aim. It sounds like something we always want to do. So why is it that we're getting perhaps cautious about the way in which this is phrased? I think one aspect of caution for me is what do we mean by rights? Where are these rights coming from? So if you look at the backdrop of the English Constitution, so not necessarily the Scottish, it's very different. I'm recognising the Scottish Constitution has a different history. If Miller Cherry taught us anything, it is that Scotland has a very distinct constitutional history. So we've all learnt this. But what you'll find when you look through the backdrop of how we deal with the UK Constitution and how English law has looked at protecting individual rights, we have not historically traditionally relied on legislation setting out very clear rights that we want the courts to go away and protect. We've relied on a combination of legislation setting out individual rights and a huge amount of common law setting out what these rights are and how the courts go away and protect them. And these common law rights are not just used in the sense of standalone provisions that can influence how we develop contract law, how we develop tort law. They're also used when we interpret legislation. So we're used to a long constitutional history of individual rights being found not just in legislation, a long history of courts not just being told, go away and interpret this right in line with the intention of Parliament, but a much longer constitutional history of courts being able to draw on background constitutional principles when interpreting these rights. So one of the concerns we might have when looking at how this panel goes through is, what do we mean by these individual rights? How far are these individual rights going to be seen as just property rights or just rights set out in legislation? And how far will these protection of individual rights continue to protect these long-standing common law rights that we find running through the history of the UK Constitution and through English administrative law? My other concern is individual. So it's all very well saying we want to protect individual rights, but I think when we think about protecting individual rights, sometimes we see it very much as the rights of one particular individual or as an aspect of negative liberties. And we tend to forget that there are also communal rights, rights that are enjoyed by everybody, that might not necessarily be enjoyed by one person to a greater extent than other individuals. So one of the concerns of just protecting individual rights is, how far will this make it harder to protect things like environmental rights? Or how far will it make it harder for the court to continue what it has been doing by drawing on different public reasons that affect everybody to preserve rights? So things like the right to reasons in planning decisions, for example, where there's been a lot of drawing on the public's need to know, which then bolsters aspects of when you need right to reasons for particular decisions. So how far will this focus on the individual undermine these other kind of communal rights to protect everybody? And third, when we think about individual rights, my third concern of this first point is, when we're thinking about individual, that means we tend to ignore this growing protection of constitutional rights. So a lot of what is being done in the case law recently, and in the cases that Sam has mentioned, is drawing on protecting the rule of law, or protecting aspects of the UK Constitution, or protecting the ability of individuals to get to court to protect their rights. And these are very important rights. If you don't have a right of access to courts, how do you get to protect your individual rights from over-intrusion by an overactive state, or from excessive intrusion by the state? So these important public rights, in a sense, also need to be preserved. And a lot of the cases where we see accusations of activism is where the courts have been drawing on protecting access to courts. So I think when we're thinking about how these things go through, when we're trying to say, well, we want to protect individual rights, to protect these legal rights, what do we mean by legal rights? Are we just looking at legislation? Do we want common law as well? What do we mean by individual rights? Are we going beyond just rights of individuals to these public rights? And are we also going to be protecting these underlying constitutional principles? And all these are law. They're legal rights that we're used to seeing protected. They're not necessarily political intrusions. So I think those are things that we need to think about, because the smaller you define your rights, the easier it is to say the state isn't being overbearing. So when you're thinking about what you mean by an overbearing state, you have to balance it against, well, what are the rights we're protecting? There's a balance between the two. So I think we need to be careful about how far are we defining these rights, and what does it mean to protect these legal rights. So my second is this idea of what we want the panel is being told we have to make sure that the law is not doing. So the aim of the panel is to make sure that judicial review is not politics by other means. And as Sam has already very rightly pointed out, you can't just say it's political because you're politically motivated, or because it's a political subject matter, or because it has political consequences, because that would pretty much count for every single case that is going, not just in judicial review, but also in other cases too. You can bring cases in private law and contract law or tort law and competition law for political motivations, or they will have political consequences. So if we're thinking about it not being political by other means, we have to dig a lot deeper to see what we think that might mean. And some of that is coming from understandings of reimagining what we think the rule of law is and what we think the role of the court is. And this is why I think some of the arguments that Sam was referring to that seems to be putting kind of background pressure is coming from this idea that it's the role of the court to protect the rule of law, but it's not the role of the court to be a guardian of the Constitution, and a perception that the court is becoming a guardian of the Constitution, and that is going too far. And in doing so, this is becoming political. Now, this is going to get a bit technical, so I'll try my best. when we have us sad administrative law academics get together and think about how do we delineate between legal and political, we tend to do so from 3 dimensions. So it's going to get a bit complicated. I'll try my best. So one dimension is the constitutional. So we have to think about what is the UK Constitution, how does it work, what are the different institutions of the Constitution, and how do we make sure they respect each other. Okay. The second dimension we tend to use is institutional. So we go away and we say, who's composed of the court? What do they do? What is their job? What are they allowed to do? What is their particular role? And the third one is the one that is finds hardest to explain, is what we call epistemic, which is a posh way of saying different people have different expertises. It's a good idea to kind of listen to those with greater expertise than us. It's a very posh way of saying, nice idea to think about if someone knows something better than you or is better at evaluating information, it's a good idea to kind of pay respect to their particular assessment. And in this point, I want to focus a little bit more on the institutional and epistemic, and I'll come back to constitutional when I look at Lord Folkes's kind of second do, what he wants the panel to be achieving. And when you look at these factors, you realise that this wonderful simplistic politics is about policy and courts is about law just does not work. Because when you go away and look at the different ways in which courts act and legislatures act and governments act, they've got different aspects of their skills. So to give you an idea, when we think about institutional features, we think about legislatures who can see a whole load of different policy decisions. So we think, well, they must be very good at taking policy choices because they can see all the different viewpoints. But when you have a court, they've just got one person arguing the decision is wrong and the government saying, no, it's not. So you've only got 2 viewpoints before the court. But what that misses out is sometimes a general broad policy decision can have consequences in an individual case that Parliament would just not have been aware of. So to give you an example of this, there's a recent decision in the Court of Appeal, Johnson, which looks at universal credit and the way in which you balanced out how you distribute universal credit in certain circumstances. And it recognised that if you're an individual who was paid on the last day of the month, this had quite serious consequences for how universal credit worked. Because in some instances you might have 2 salaries, and in other months you'd have 1, but then having universal credit that would work on how much you earned and then changing it would just lead to all sorts of fluctuating income levels. So it's an example of something that you might think is a good policy balance, but in an individual circumstance gives rise to all sorts of consequences that might not have been expected. Do you look at that and say this is a policy decision to point that out? Or do you look at that and say, no, I am making sure a policy choice is actually implemented in individual circumstances? And so to look at that and say, well, this is dealing with allocative decisions, it's policy, misses out that it could be pointing out that a policy doesn't work in a particular instance. And so the executive needs to kind of deal with this in certain circumstances. So in that case, it's seen as Wednesday unreasonable not to respond when they're aware of the problems that were arising in these particular circumstances, which gives the executive the chance to rethink and come up with a better rule that achieves its policy in those circumstances. So it's not clear cut. The same happens when we come to aspects of epistemic. You might say, well, obviously the legislature has all this element of expertise and can balance and weigh it up. But one thing the court has in its corner is it has the expertise of understanding, looking backwards, what these long-standing principles are. So it can draw attention to different executives to be able to say, look, when we look at these particular circumstances, they don't work out. When we look back, we can see that a long-standing principle is being ignored in these particular situations. And this is how we deal with the principle of legality. It's about pointing out to the legislature that a long-standing principle hasn't worked. And that brings me to my final point, which is this idea that it's all about preserving the elected government's right to govern. And this is where the constitutional issue comes in that I have issues with. First, the scope. It isn't the case that every single judicial review case is made by an elected government. A lot of judicial review cases are made by individual civil servants implementing policies, so they're not elected. Second, The government is indirectly elected. It is not directly elected. It holds power to the extent that it has the confidence of the House. So we need to make sure there are sufficient political controls as well as legal controls to make sure this works effectively. But I think my bigger issue with this is the picture it is painting of the UK Constitution. It's painting a picture of the UK Constitution of executive dominance. This idea that you elect a government, the government is in power, it has an electoral mandate, and its job is to push through its agenda in those 5 years. And if it can't do that, it is not being an effective government. Now, I have nothing against ensuring the government is effective and can implement policies that have proper democratic scrutiny, but I have a lot of concerns about a view of the Constitution that doesn't recognise the UK's constitutional history, which relies on a delicate balance of power between the executive, the legislature, and the courts. And I think that, for me, is where the real danger lies. If we start reimagining the Constitution as one that just gives carte blanche to the executive to act within 5 years without sufficient political and legal accountability, with legislatures dealing with policy and courts dealing with the law, even though that line is incredibly difficult to draw. Thank you very much.
Thank you so much, Alison. That talk was really, really enjoyable. A brilliant overview of public and constitutional law. We've had one brief question in the chat just before I hand over to Meg. Could you please repeat the name of that UC case once more?
Oh, that's great. It's Johnson. It's in the Court of Appeal. I could email you a reference or something, or I could go into the chat and put the reference in, couldn't I? Would that work?
That would be perfect. Yeah, that would be great. Thank you so much.
Okay.
Okay, and on that note, I'm happy to hand over to Professor Meg Russell. Meg.
Well, thank you very much, and thank you for inviting me to speak at this event. And I would say once again, I think my remarks are going to dovetail beautifully with where Alison ended. So without much coordination, this is working out very nicely so far. So we were invited here to talk about the commission that was promised in the manifesto. You read out the words as to what the commission was due to be: Constitution, Democracy and Rights Commission. The immediately preceding words to that on the famous page 48 of the manifesto were that after Brexit, we need to look at the broader aspects of our constitution, the relationship between the government, parliament and the courts, the functioning of the royal prerogative and the role of the House of Lords. So we now, as we've established, have something approximating to a commission chaired by Lord Fawkes, announced about 10 days ago, but that's only looking at quite a narrow aspect. I'm the non-lawyer on the panel, so I want to widen this out a bit in my presentation to talk about the other aspects that might or might not be included in a commission if it's still coming. Those things about relationships between government and parliament, reform of the House of Lords, etc. There's an irony which has already been pointed out by what Sam said, that the ostensible reasoning behind some of this need to review is wanting to protect parliamentary sovereignty, wanting to protect the political as opposed to the legal constitution. So talking about parliament, there are clearly connections between our two topics here, parliament and the courts. And the really obvious irony, which many people have noted, is that the court cases which seem to most aggravate the government and seem to motivate to an extent this review were cases where the courts, in the two Miller cases, actually stepped in to protect the role of Parliament in decision making. And certainly in the prorogation case, many people will know that Jonathan Sumption, who gave those Reith lectures, which were controversial among some people in the public law field because he was concerned about the growth of judicial interference in policy, if you like, wholeheartedly supported the Supreme Court's decision on the prorogation. So there are lots of complex ironies here. But moving to look more at the other aspects of the role of Parliament, what kind of clues can we find beyond this to the government's, the direction of the government's thinking? There are some other words in the manifesto which I think are worth quoting here on the slightly less well-read page 47, which say the failure of Parliament to deliver Brexit the way so many MPs have devoted themselves to thwarting the democratic decision of the British people in the 2016 referendum has opened up a destabilizing and potentially extremely damaging rift between politicians and people. Now, I have a few problems with this statement. Firstly, simply putting such a negative and kind of inflammatory statement about Parliament in the manifesto of a serious governing party is to me a problem. But second, just in the sort of veracity or at least the interpretation of the statement, who exactly were these MPs who devoted themselves to thwarting Brexit, which generated the famous general election slogan, "Get Brexit Done"? Well, Boris Johnson, Jacob Rees-Mogg and Dominic Raab all voted against Theresa May's Brexit deal twice, while Priti Patel did so 3 times on all 3 occasions. And these people are now in the cabinet. So what looks like a rallying cry that disloyal MPs should have supported the government actually comes from a group of Conservatives who did exactly the opposite of that. So there are lots of contradictions here. But the argument about Parliament's role in Brexit wasn't so much one actually about Parliament and government, a disagreement between Parliament and government over a matter of principle, which was decided in the referendum. It was an argument between different members of the Conservative Party as to how to interpret in detail that in principle decision and how to implement it. And that, to me, is the political truth. And if you want to read more about that, a plug for me, I've got an open access article in the journal Parliamentary Affairs on this whole saga, which is called Brexit and Parliament, the Anatomy of a Perfect Storm. And there's a summary of it on the Constitution Unit blog, which is called Brexit and Parliament, Where Did It All Go Wrong? So that's all very freely available. So what's happened since? We had the general election to get Brexit done. What's happened since in terms of the government's relationship with Parliament? And what might the Prime Minister's kind of preoccupation be if there is indeed a further commission looking at the role of government and Parliament? Again, I find a number of things, indicators, which are quite troubling here. One is the nature of government under coronavirus, where partly by necessity, there have been many key decisions taken through delegated legislation with very limited parliamentary oversight. At the beginning of the crisis, that looked quite well justified, but as the time of war has worn on, that behaviour has become less and less defensible, with questions, for example, on the wearing of face masks in public places, debated in the media for weeks before a law was rushed through without any parliamentary oversight and came into force within 24 hours of being published. The Bingham Centre and the Hansard Society have both been tracking these kind of things really well, and I would commend their work on this. But while it's worrying in itself in the context of coronavirus, I think it's more worrying if we think about the possibility that it might shape a longer-term executive mindset in something which is essentially a young, new government, shape a mindset on other policy areas beyond coronavirus, which is intolerant of parliamentary scrutiny. And the reason to defend parliamentary oversight is not just a principled one, it's actually an entirely pragmatic one as well, because policies which are published well in advance and subject to proper scrutiny wind up making better considered law. And we haven't seen very much of that over coronavirus. In the Commons, there have been various other flashpoints, like the government's determination to choose the chair of the liaison committee, contrary to previous precedent. Although Bernard Jenkin may well do a perfectly decent job at chairing the committee, it's the principle. And this has also been referred to in Sam's presentation, the attempt to very abruptly end the hybrid House, disenfranchising so many MPs, many of them shielding from participating in that decision about how the House was run. All of this suggests, as I think Alison has already referred to, a very strong executive mindset, which clearly believes that number 10 knows best, and it resents interference, even from Parliament. That was the Commons. With respect to the Lords, there have been 2 particular things of note, which some people find some hilarity in, but I find, again, rather troubling. First, there are the periodic briefings about the possibility the Chamber might move to York. Again, these seem to come straight from number 10 and nowhere else. These also seem to betray to me two fundamental misunderstandings. First, about the substance, parliamentary relationships, that separating a chamber from the government that it's scrutinising would be extremely difficult. And separating it from the other chamber, in partnership with whom it must agree policy, would be very risky. Good communication between government and parliament and between the two chambers of parliament is essential to avoid these relationships descending into acrimony. The second misunderstanding with respect to the York idea is about process. The government has only just been forced to admit, due to a private notice question in the House of Lords in the name of George Young, former leader of the House of Commons, former cabinet minister, Conservative cabinet minister, that the location of Parliament is ultimately a question for Parliament itself to decide, not government. And actually, there's very little sign of interest in a move coming from parliamentarians. Indeed, there are many signs of both frustration and outright derision at this idea. The other thing with respect to the Lords, obviously, was the peerage list, which was published on the same day, a week and a half ago, as the Commission on Judicial Review was announced. Leaving aside the personalities and the suitability of any individual candidates, this was a disappointingly long list of new appointments, 36, and also very tilted towards the Conservatives, who already have a preponderance in the chamber. They'll have 82 more seats than Labour once these people have been sworn in. The former Lord Speaker, again a former Conservative cabinet minister, Lord Fowler, has expressed something close to despair at these publicly at these announcements, the announcement of these peerages, as he and others in the chamber and indeed in the House of Commons have been working hard in the last few years to bring the size of the Lords down from about 800 gradually towards something more like 600 or 650. Theresa May showed great restraint in her appointments to the Lords, and effectively all of this hard work of all of these people has been undone in one fell swoop through this peerage list. The danger with both of these developments with respect to the Lords is that they further damage the reputation of the chamber, making it an increasing source of ridicule. That, of course, is bad for Parliament, but it could, if you're a cynic, be said to be good for government, because it weakens Parliament against the executive by damaging its reputation and also, to an extent, its ability to function. If you put these kind of concerns about Parliament together with those of many lawyers regarding the courts and also people concerned about things like the civil service, you do see a somewhat consistent pattern. A desire to concentrate power at the heart of the executive, to weaken scrutiny and oversight, and to weaken checks and balances in the Constitution. If you add that to some of the populist rhetoric of Parliament, for example, in the words of the manifesto, thwarting the democratic decision of the British people, or of the famous headlines about the enemies of the people and parliamentarians as saboteurs or mutineers, the pattern is really quite troubling, with clear resonances in other democracies which are seen to be backsliding and moving away from liberal pluralist constitutionalism. If you want to read about some of these worrying resonances, I'd plug some other people's work. For example, Anne Applebaum's book, which was published just a couple of weeks ago, is really insightful on the resonances in Eastern Europe, and she knows the Conservative Party as well. And Levitsky and Ziblatt's book, How Democracies Die. I should have said Applebaum's book is called Twilight of Democracy. Levitsky and Ziblatt's How Democracies Die is much more focused on the Americas. And we'd all see clear resonances there, I think. So returning to the start and the question of the Commission, it's not clear whether or not there'll be a review of these wider aspects and whether there'll be any serious attempts at parliamentary reform. I would say in defence of Parliament that a majority of 80 in the House of Commons in no way guarantees that you can get anything you want through that chamber, and there's actually a lot of unease on the government backbenches. But if there is to be another review, there is of course a very big question about the extent to which it will be open and consultative with the public. At the Constitution Unit, we believe that if fundamental questions are to be opened up about relationships at the heart of our democracy and constitution, there should be careful public deliberation on those questions in order to get away from knee-jerk responses and opinion polls. Arguably, after all of the difficulties over Brexit, whether or not we have a commission, it's a good time to look at these issues and what the public think on deep reflection. We have unfortunately become a very divided nation. If you look at polling on things like the prorogation, it's completely polarized along, or it was at the time, completely polarized along Brexit lines. If you conduct proper public deliberation through something like a citizens' assembly, you can get away from that. Ideally, a body like that would put participants behind something like John Rawls' famous veil of ignorance, to consider what they'd want from the system in an abstract sense, without knowing whether they're young or old, black or white, rich or poor, or whether the governing party is a party which they support or oppose. In those circumstances, I'm pretty optimistic that most participants would want a pluralist system with a free media, independent civil service, strong executive accountability to Parliament, and a reliable safety net through the courts. But whether or not we have such a commission, and the extent to which the commission we have, or any other one that we will have in the future, is going to be subject to such consultation, remains to be seen. Thank you.
Thank you so much, Meg. I found it really interesting that you, among other points, made the point about proper public processes of deliberation, which I'm hopeful will actually dovetail really nicely with the substance of what Michael is about to discuss with us, amongst other topics. So with that in mind, I will hand over the floor to you, Michael, to take the reins.
Absolutely, Adam. Thank you very much, Meg. There was a very interesting piece that Meg wrote a few months ago with Alan Runtwick, which makes exactly this point, featuring some of the things that we've been talking about at the Bingham Centre in terms of participation. And for me, that is vital. So for my presentation, I'm going to take a steer from the terms of reference of this independent review of administrative law, as well as the chatter I've heard on the street for the last 9 months since page 48 was printed. And I'd like to keep the following 4 concepts in mind as we go through this presentation. The first, as has been expressed by all of my fellow speakers, that judicial review is vital to the practical realisation of the rule of law. The second idea, that even as currently construed, judicial review and enforcement of judicial review are not sufficiently compelling to enforce universal conformity with public duties. The third, and this starts to broach into some of the stuff that Meg was just talking about, judicial review is one of many tools that citizens use in a democracy to get what they need and to get what they want. And as currently composed, this independent review of administrative law thinks far too narrowly and needs to think more from the citizen's perspective. And the fourth notion is that we are exactly where Meg and I and the Institute for Government said we were going to be in February with this. We have an elite commission with people who are involved at the very zenith of judicial review, and the notion of people who have lived experiences of judicial review of communities is absent from the current members of the group, and as such there is a gaping hole for activists and community organisations who are often interveners and claimants in judicial review cases to be represented in shaping how it's going to work. So going to the first, the notion of the importance of judicial review to the rule of law. At the Bingham Centre, as our name suggests, we try to advance and promote the notion of the rule of law that Lord Bingham expressed in his book on the matter. And whilst I won't go through all of the aspects that he was discussing, the exercise of powers in good faith for the reason that those powers were conferred was absolutely crucial to his concept of what it meant to be in a rule of law state. And again, going back to some of the points that Alison was making, your rights, the quality of judicial review, all of these things are nugatory if you don't have the opportunity to bring these before a competent court. And the current state of judicial review is such that your own committee, young legal aid lawyers, public law projects, many of those who are on this call will be very aware that the legal aid regime, exceptional case funding, are insufficient for the vast majority of claimants who have had some issue with the exercise of a power by a public authority to actually get a remedy in their situation. And in that situation, taking into account many of the points that civil society organisations have raised with me in our work, public authorities can often get away with acting in manners that are not lawful, in making irrational decisions and not taking into account all of the factors that they should have in the way that they deal with individuals. And access to justice, again, reciting some of the comments that Lord Reid made in his love letter to the rule of law in Unison, sees the judicial review case serve as a means of promulgating principles of general importance that both enforce rights and create justiciable rights in the future. And those are important things to hold on to with achieving the rule of law. So with that context set out, I'd like to look at a particular judicial review that, as a campaigner and then as a legal writer, has been something I've thought about quite a lot and has really made me think about the schism between the judicial review case and the effect of its judgment for those on the ground. And that case is G and Southwark London Borough Council in 2009. So in terms of the legal regime for this, 2002 statutory instrument provided that those aged 16 to 17 without appropriate accommodation should be deemed in priority need for the purposes of the 1996 Housing Act, and provided that other criteria were met, that they would be entitled to assistance from a local authority housing department. Despite this, many local authorities at the time decided that they would provide accommodation under a different provision, Section 17 of the Children Act, meaning that they would have no ongoing commitment to providing accommodation and other services to 16 and 17-year-olds who presented as homeless to them. G, the claimant in this case, challenged a decision made by Southwark Borough Council on the basis that he met the criteria as set out in Section 20 of the Children Act and should therefore be treated as a priority need as he required accommodation. The local authority had argued that G's approach was too simplistic and that they should be allowed to consider all of the sources of accommodation available to the child in ascertaining whether or not they should provide the accommodation. And the House of Lords at the time allowed G's appeal, rejecting the local authority's argument on the basis that though some would not be relevant children for the purposes of the Act, G certainly was one, and where a 16 or 17-year-old presented as homeless, there was a duty under the Children Act to accommodate that child and provide wraparound services. So local authorities by the dozens started to amend their provision for housing and accommodation to homeless teens. And you'd think as a result of all of that activity and new guidance documents by their representative organisations and the local government association, that this was a utopian situation for all older teenagers who found themselves in this situation, as they were going to be looked after and all of their welfare needs met by their local authority. However, that was not the case. And where I lived at the time in Nottingham, the experience of an older teenager who presented as homeless to the local authority was varied. One might be sent to the Housing Aid Department, another to Children's Services, another completely rejected in terms of their children need assessment. And the position where a child would not be provided with accommodation and treated as a priority need for the purposes of both the statutory instrument and the Act was untenable if you looked at both the judgment of the House of Lords and the legislative regime itself. And in that instance, though thousands of children across the country had benefited from the reminder that local authorities had received through Lady Hale's judgment, children in Nottingham could not avail of the same benefits. And a few legally minded activists in Nottingham sent the judgment to relevant people at the City Council, and they would receive very dismissive and defensive responses from the local authority that were never made public either. So judicial review in that instance was not the compelling enforcement mechanism for people who had not been party to the judgment and the local authorities who hadn't been caught up in the groundswell of enthusiasm with the judgment. So, as part of a community organising approach with the organisation Citizens UK, I and a group of other community leaders set up a group which essentially had three aims. The first, that it would develop leaders amongst the population of Nottingham. The second, that we would run inventive actions on matters of public importance. And the third, that we would win on some of the public policy issues that we were fighting for, in order to prove to people that when you get together, things can actually change. And we knew that the law was on our side, but didn't want that to be the means by which we advanced our campaign ask, which was that a 16 or 17-year-old who presented as homeless would be dealt with as a priority need and provided with accommodation. So we did a series of things. We ran strategy meetings with really diverse cross-sections of the community to better understand how people experienced interactions with the housing services and children's aid departments. We would listen really deeply through civic participation methods to people who had been affected, making sure that we amplified their stories. And we held some pretty fun and visible actions, including marches, to make it visible that this was something that concerned quite a large section of young people in Nottingham. And I think the context in which we were operating was also quite helpful. For the first time in a generation, the local and general elections in Nottingham are going to be held on the same day. And in the community organising methodology, that can be a really useful focuser of the minds of decision makers who have very small majorities. And thankfully, fortuitously, the lead portfolio holder for housing within the council group also had a very small majority in his council ward. And we utilised that in building a strategy for how we could advance this campaign ask. So we held demonstrations with a number of people that separated his vote share between him and his second place candidate at the last election. We packed his surgeries, again with the same number of people, and then a barrister and I held a presentation behind closed doors with him, where we made a very thinly veiled threat of judicial review about this issue. Again, knowing in our heart of hearts that we probably wouldn't be able to get funding for it, and we wouldn't be able to raise the funds within our coalition. But lo and behold, you had a press statement going out in late December of that year, where the council said they created a new protocol for accommodating children who presented as homeless in that age range, and no older teenager in Nottingham would be homeless at Christmas time, around the sort of time that they were printing election manifestos as well. But let's not be too cynical about their intentions. So my reason for painting that vignette is that I'm trying to construe judicial review as but one of a series of tools that are often used to get local authorities to act in a lawful manner. And it is both part of the lawyer's toolkit, but also part of the activist toolkit in terms of strategic litigation that is used to achieve their purposes. Which leads me to my final point, in that if it is not just the litigator's toolkit, but also the civil society activist toolkit, why is it that legislators, legal academics, practitioners are amongst the membership of this independent review of administrative law, but our colleagues at Liberty and Justice, for example, aren't represented in membership? Why is it that we haven't, for example, included the perspective of somebody who has made an application for judicial review against the local authority? And whilst I understand the eminence of many of the members of the committee, it seems to me that there are areas of judicial review that are not represented, particularly around community care and local authority activity, which represent quite a substantial section of the judicial review caseload. And I'm sure many of our participants will echo the view that that's a very important area for consideration, which I fear will not be one of the areas of expertise that members of the panel will be drawing from. And going back to the point that Meg and I share about the nature of such commissions, there is a great schism and disjuncture between the legal community and the normal average Joe Blogs in the street, if you will. There are over 1 million civil cases that aren't brought each year because people simply don't know about the law. On these YouGov polls ranking professions, lawyers rank very poorly as against almost every other profession in terms of attracting public confidence and whatnot. And for a review panel that is essentially looking at one of the most important mechanisms for preservation of the rule of law, I think it would be a great disservice to Joe Blogs on the street if he's not asked whether or not judicial review works for him. I suspect that given the opportunity and the space and a non-leading commission that hasn't already decided where it's going, the reviewers would hear some things that are quite challenging to them that I think would only be for the benefit of the improvement of judicial review. There were certainly a number of ideas posited within the Jackson review that were looking around access to justice in judicial review that simply have not been implemented. And looking at the terms of reference for this independent review again, it seems that a particularly narrow view has been chosen from the outset that would preclude looking at wider issues of access to justice. So for me, this is a very strangely constructed review that doesn't even go so far as the highlights of page 48 for me, which seem to connote a tokenistic sense of access to justice being an important thing, whilst seeking to constrain perhaps the grounds for judicial review and rules around sufficient interest and standing, which is where I sense the notes in the terms of reference are going. So those are the overarching points that I'd make. The commission or review as it is at present is too narrowly constructed. The judicial review tool should be seen in its wider context of how it operates in our democracy. And judicial review is very crucial for the practical realisation of the rule of law, and any incursion into its ability to protect individual rights should be resisted in no uncertain terms.
Okay, thank you so much, Michael, for wrapping us up there with that really insightful discussion, and in particular raising those salient points about the limits of judicial review. And I want to draw attention, before we go to questions, for members of our audience who are interested in that broader context, how do lawyers work with campaigners or journalists to promote social justice? We do have an event tomorrow, Wednesday, the 12th of August, 6:30 to 8, titled When the Law Runs Out, Campaigning for Social Justice, chaired by our wonderful Siobhan Taylor-Ward, recent Legal Aid Award winner, and she's going to be discussing that in detail. And then we do also have other events also on Monday the 17th about social welfare law after COVID-19, as well as on Tuesday the 18th of August, a panel on strategic litigation. So if you are interested in those particularly salient issues which Michael raised at the end of his speech there, I would really encourage you to attend those. But now I'm glad that we can move to audience Q&A. And so if you do have a question for our audience, please do input it into the chat and I will feed that to our panel members. I'm just going to kick off the questions here with something I wanted to ask, which was a question of to what extent this is new territory. I want to understand the historical context of where we've ended up. And one of the reasons why I want to ask that is especially with respect to this new independent review into judicial review, I want to understand to what extent have we been here before? Because in 2014 and 2013, the coalition government was consulting on proposed reforms to judicial review. And I quote the foreword, which was penned by the then Lord Chancellor Chris Grayling in the government response to consultation, in which he said, "I believe in protecting judicial review as a check on unlawful executive action, but I am equally clear that it should not be abused to act as a brake on growth. In my view, judicial review has extended far beyond its original concept, and too often cases are pursued as a campaigning tool or simply to delay legitimate proposals." So to what extent is this all deja vu, and what is new in the government's latest independent review? And I don't know who wants to take that first. If anyone, Alison, I'm going to throw it over to you.
I thought I might get that one. Thank you. You're right. For those of us who went through the reforms that were made to judicial review from the Criminal Justice and Courts Act, which then amended Section 31 of the Senior Courts Act, this is to some extent not new. So exactly the same concerns were being expressed. And that led mostly to procedural reforms, which have already made it more difficult to bring judicial review actions through those procedural reforms. So I think Michael was mentioning that with regard to difficulties with regards to getting through the permission stage. There's all sorts of things of modifications to protective cost orders. There's modifications for instances where it wouldn't make a material difference to you, even if it was unlawful, then you can not get standing and you will not get a remedy. So there's all sorts of things that have already been made. What has been interesting is how these have been interpreted. And so, although these procedural reforms are there, the courts are very conscious of the fact that you have to interpret that against a backdrop of access to the court. And they've also recognised in a lot of cases, it's very difficult for the court to say, this won't make any material difference, without going away and looking at the substance and the policy, which the court can't do. So it was a very odd reform in a sense of go away and tell us that even if we'd got this right, well, this had made a difference. And the courts are saying, well, that's going to be very difficult for us to do without doing a full substantive policy analysis, which we're not able to do in these cases. So there have already been procedural reforms, and those procedural reforms were pushed from an agenda to try and ensure effective governance. But the cost there was predominantly about concerns of planning decisions. And we also have, as came out last week, the white paper on planning law, which will move those elements as well. So the real concern was, we want to take big planning decisions, you keep going to court and stopping us, or we can't do our governmental projects. I think the added layer here is the concern about the context of the Brexit decisions that we've been bringing up, the Miller-Cherry decision, the first Miller decision, and the concern in cases like Sam mentioned in Whiteman, which is the concern of people going to court to enforce constitutional principles, enforce the law, and often enforce parliamentary sovereignty, but in a way that then stops the government from, I think that angle is new. But the angle of abuse of process has been there, and particularly the procedural reforms has been there. So the other things that are new here is codifying judicial review. Because I'm not used to seeing requests for codification of judicial review principles. That's quite new, the suggestion that it will be codified. And there's all sorts of concerns as to what that might mean and how that goes forward. So I think it's there, but it's building on those concerns, perhaps because the earlier reforms didn't quite go as far as the government thought they would do.
I wonder, I want to ask an iteration of that question and address it particularly to Meg. I wonder, in addition to those differences which you've identified, Alison, I wonder what the differences in the political context of the 2014-2013 consultations and now. Was, in your estimation, was the coalition government perhaps more or less amenable to or less willing to challenge these fundamental principles in the way that the current government perhaps appears less constrained by current constitutional norms? So yeah, any thoughts you may have on the differing political contexts there as well? I think very much.
That's a good question. I raised my hand because I wanted to say something else that was even broader, but I'll come to that question. This is another opportunity for a shameless plug for the Constitution Unit, because we've been celebrating our 25th anniversary this year. The Constitution Unit was formed in 1995, which was in the expectation of a government that was going to have a big constitutional reform program, because Labour back in the 90s had lots of ideas, many of them not very well worked out in detail, and the unit was created effectively by some civil servants in exile who thought that Labour wasn't adequately prepared to implement such a big program, who laid some of the groundwork and raised some of the evidence, comparative evidence, etc., etc. And we've been reflecting on the 25 years as a consequence of that. And if you want to read about it, there's lots on our website. But if you think about what motivated that reforming government for a program of constitutional reform and what seems to be motivating this one, they are almost the opposite. I mean, Labour implemented devolution to Scotland, Wales and Northern Ireland, and ultimately London, the Human Rights Act, removal of the hereditary peers from the House of Lords, freedom of information, a number of other things. It was never particularly well articulated, but that was essentially about decentralizing and enhancing checks and balances. And that's partly because of the, which might lead to the point that you want me to address, partly perhaps because Blair was never confident that he was going to win a majority, and he had these talks with the Liberal Democrats, and the Liberal Democrats are very much in favour of those kinds of reforms. Blair himself was never hugely behind them, and Derry Irvine, who was implementing many of them, didn't believe that you needed an overarching theory. But essentially, if there was one, it was about greater pluralism, whereas now we seem to be talking about reining that back. In terms of the comparison with the coalition government, I think the clue's in the name, really. I mean, you know, they were two parties come together with different sort of histories and traditions, different policy priorities, and there were lots of disagreements. And, you know, the Liberal Democrats were not necessarily particularly comfortable with reining back rights. You know, that's not in their DNA. And so I'm sure that is part of that story. But although, you know, I would say, although I said this already, we now have a single party majority government with a large majority in the House of Commons, all political parties are coalitions. And I think the current Conservative coalition, as reflected in, for example, Anne Applebaum's book, which is all about divisions on the right of politics all over the world, it's a very uneasy coalition between people who have sort of different fundamental principles when it comes to the Constitution. So it's not necessarily going to be easy now, although it was clearly difficult then.
I want to follow that up quickly with another question, which is to what, obviously you've mentioned there that the government does have this large majority, and so that may present more problems, or it would be naive for the government to think that they can very easily get their reform agenda through. But this is a government which hasn't particularly shown that it's afraid to withdraw the whip from people who displease it. And also we can see from the cabinet that the cabinet is largely made up of ardent Brexiteers. To what extent do you think this political culture in which loyalty is rewarded and disloyalty is punished so severely, to what extent do you think that will have an effect on this broader constitutional reform agenda?
Well, that's a really interesting question. And I think it remains to be seen, because we are in these extraordinary times where the focus is on, firstly, coronavirus and all this emergency stuff, and secondly, Brexit, where there's policy that has to go through Parliament by the end of the year. So we're not in normal times by any means. But I think that, as I said, there are lots of signs of discontent on the Conservative benches. You know, the procedure committee chaired by Karen Bradley, who is a Conservative, were very unhappy about the ending of the virtual parliament. She was very critical, proposed hostile amendments. The Public Administration and Constitutional Affairs Committee in the Commons is chaired by William Ragg, who is also a Conservative. He's also a Brexiteer, but he's been quite outspoken against the government on a number of issues. The Liaison Committee is now chaired by Bernard Jenkin, also a Brexiteer, but a Brexiteer who famously had something of a feud with Dominic Cummings, as in that film where he's played by Dominic Cumberbatch. So they're not necessarily a happy and united ship. And in the end, governments simply can't go around keeping on sacking their backbenchers, because, you know, we're all talking about the fundamentals of the British Constitution here. The government does depend on the support of its parliamentary party, and there's only so far that you can push it. But I wouldn't want to go further than that in prediction.
Thank you. I want to bring Sam and Michael into the discussion now. And I suppose I want to ask this question to you based on your different perspectives. Yours, Sam, as a practitioner, and Michael, from your perspective as someone, as a civil society actor, for lack of a better term, an activist. And I want to understand how you think the legal sector ought to respond to this proposed constitutional reform agenda. Is it the case that lawyers should engage fulsomely with this proposal and this independent review and try to influence it from within? Or are your concerns so much that to engage even minimally would be to lend this independent review an air of legitimacy, which perhaps you don't want to endow it with? And so I'm very interested, I suppose, in understanding the different perspectives on how the legal sector ought to respond. So I'm not sure who wants to take that first, or perhaps I'm asking completely the wrong question. I'm completely articulating it improperly and poorly. But Michael, you've unmuted your microphone, so I'm going to hand it over to you first.
Yeah, I'll have a go. So I think the answer that I'm allowed to give is that we believe in constructive engagement and influencing where a process that has a bearing on essentially our constitutional rights and the reviewability of government decision making is something that we should try to meaningfully influence in an appropriate sort of challenge, not as a wrecking mechanism, but to improve things. I think what people on the call and members of the panel and our wider colleagues should be up to is trying to give the commissioners an understanding of, I think it's the administrative unworkability of the rubric that they're working towards, and how they, as in the drafter of the terms of reference, seem to have taken quite a superficial and I think quite a confused perspective on some of the terms that have arisen in the public discourse post-Miller, etc. And I think what would be helpful from us are exactly the sorts of activities that the Legal Action Group and Public Law Project and others on the call have been up to, in bringing to the attention of parliamentarians through all party parliamentary groups how the opportunities for advocacy that they have can be used to raise some of these issues of definition. In my view, both this independent review of administrative law terms of reference and page 48 got very wrong. And again, I think in terms of campaign strategy, because this has been pitched as such a closed elite commission rather than something that was more public and participatory, it probably is in conversation with influential parliamentarians or party parliamentary groups, organisations that have close connections to members of parliamentary committees, that this thing will eventually peter out. I don't have any high expectations of this resulting in anything meaningful or concrete, and I think the more problematic issues that currently concern the delivery and experience of judicial review practitioners is probably more important to bring to the attention of decision makers than this list of 4 items that Lord Fox and co have raised.
Maybe we can judicially review it. I don't know. There's a delicious irony there. There's no, I think, and actually this this ties into one of the questions on the Q&A, I think, from Lara Scott, which was about public understanding of the separation of powers in the wake of the prorogation case. I actually think, if anything, public understanding of the Constitution in the wake of the prorogation case declined, because we effectively left the field clear for the governments to put in place this sort of absurdist, Charles I view of the Constitution, where anyone suggesting that King Boris doing something was doing something unlawful was automatically a traitor, and so by enforcing the law, the court was behaving disgracefully, and judicial fiat, I think, was one particular term that was used. And I think that what the government did very effectively in the aftermath of that case was push this narrative of democracy as a sort of once every 5 years exercise that then, as Alison, I think, very, very articulately put forward, this idea of a executive dominated government which gets you win an election, you get 5 years and it's to go mad. And that's obviously not an accurate description of the Constitution, but it was very, very effectively put out there. And so while I should say that in terms of each of the individual lawyers on this commission, if any of them was to ask me to act with them in their specialist field, I would just be incredibly excited and incredibly honoured, because within their specialist field, each one is brilliant. None of them are specialists in constitutional law. None of them are recognised experts. And given a constitutional case, I would not be turning to them. And that is not to denigrate their expertise, because as I say, they're incredible lawyers, but they're just not constitutional lawyers. And I think it is very significant that the UK has some of the best constitutional lawyers in the world. People like Sir Geoffrey Joel, who was formerly director of the Bingham Centre. Countries around the world literally ring him up and say, come and write our constitution for us. And yet he's not been asked to join this. Lord Pannick, Alison, Paul Craig, all of these are, Meg, all of these are people who are world-renowned experts in the Constitution, and they are nowhere to be seen. But we've got people who are court of protection lawyers, which is a very difficult field of law, but it's not constitutional law. So I think the Commission is problematic. I don't think the Commission is particularly keen to hear what we have to say. But I don't think that we should leave the field clear to sort of for them to ill-define and misdefine our constitutional debate. And I think that lawyers, as a species, if you like, have a real responsibility to do a little bit more public education and really, really set out what we're about and any impact that we're going to have. And I was half joking about JRing. I am absolutely sure they will ultimately make a misstep and will be open to JR. But beyond that, what Michael was talking about, lawyers need to work with NGO and work with MPs and work with community campaigners to make sure that whatever this commission comes up with, and I have fairly low expectations as to both the impacts on democracy and the rule of law, and simply the quality of policy that is going to come out of that commission. Whatever comes out, we have to make sure that it then gets subjected to proper public debate and scrutiny. And I mean, you never know, there's even the off chance we might be able to turn it into something good. I'm always hopeful.
I think that's a really good point on which to ask this next question, which has just come in from the audience, which is, if you were on this government panel, what reforms to judicial review would you advocate? What criticisms of JR are fair and not just motivated by a desire to hoard power with the executive? So a bit of a desert island discs style question there. If you had a magic wand and you could fix judicial review, what would you do? So I'm going to throw that open to everyone. I'm not sure who wants to go first on that one.
I'll have a look. I think I would end the debate about proportionality as a freestanding ground of judicial review and have it.
Applause there from Alison and Sam. Alison, Sam, Meg, any thoughts?
I'll try. I think I would have a good hard look at legal aid, because the consequences of reducing legal aid means what do? You go crowdfunding. And I think there are fewer controls over ensuring that crowdfunded judicial review applications are not motivated by political point scoring than there are over legal aid judicial review cases to make sure they're not motivated by political point scoring. So maybe think more about, if you are really serious about making sure judicial review isn't being abused for political point scoring, maybe think more carefully about ensuring there is publicly funded legal aid cases and less resort to crowdfunding, where there's been some brilliant cases through crowdfunding, not to criticise the way in which it's being used, but one's regulated, one is not. So maybe it's time to take a good hard look about how those interrelate to each other, if that's your aim, to try and stop this politically motivated actions. There you are, that's mine.
I was going to say that. Not for the noble reasons, just because I'd like to be paid a bit more often for work on JRs, and so I'd like some of my clients to get public funding. More seriously, and because Alison took my broad point, I'm going to make a technical point. I think we need to reform Article 9 of the Bill of Rights, because increasingly it seems that parliamentary privilege is being used as executive privilege to protect the executive from scrutiny. And the government's lawyers attempted to do that in military to start with, and were unsuccessful. But I think it's much more successful in the JRs or other challenges that don't ever make it to court. And I have, for example, seen the Bar Standards Board refuse to look into lawyers who give, well, I was going to say misleading, entirely false and incorrect and insulting legal advice in Parliament, and I've seen it used to protect, well, the Leader of the House and various other instances, and all of which were members of the executive coming and saying something in Parliament. So that, and then claiming the protection that was ironically originally intended to protect parliamentarians from an overweening executive. So it is in effect, the purpose has been reversed, and Charles I is benefiting from the article of the Bill of Rights that was created to stop people like him. So I'd reform that.
Thanks, Sam. We have one final question which has come in, and which I think, Meg, you're very well suited, I think, to take the lead on answering, which is a question from Crash. And the question is there a link to be drawn between the UK government's aversion to checks from Parliament and the judiciary and recent tensions between the government and the civil service?
Yeah, well, I think that was implicit in what I said, and I absolutely think there is. I think the thing that we need to worry about here is the broad mindset, and I wouldn't have gone so far as Sam in talking about King Charles, but there's at least a grain of truth in that, and the desire to centralise power and to not face scrutiny. It applies. I mean, I would go. It goes beyond that to an independent public service media as well, I think, because we saw some quite nasty scraps during the general election, not just with the BBC, but also with Channel 4, asking too many awkward questions. I mean, sometimes you could say the media pushes it too far. The ice sculpture or whatever it was, it clearly angered some people in the Conservative Party, but all of these things are essential to a functioning democracy, and I think partly it comes maybe in the wake of a referendum where you simplify democracy to a one-off vote on a single question, and that's without the usual checks and balances. But we all know that a functioning democracy depends on pluralism and protection of minorities, and not just plebiscitary rule. On the King Charles point, which I quite like, and it's an opportunity to raise something which I've often raised before, and which you referred to when you were kindly introducing me as somebody who's done quite a lot of work on the policy impact of Parliament. I think this idea that the executive has untrammeled power in the British Constitution is very well established in people's minds, but it's not well founded. And actually, as somebody who has studied Parliament in detail, and I mean, you would say this with respect to the bits of the Constitution that you know about as well, there's a lot more goes on in Parliament than people assume. Yes, most government bills go through, but some government bills never get published, and some get withdrawn by the government. Some get heavily amended. Tony Blair had a huge majority in the House of Commons. He wanted to introduce ID cards and limit trial by jury. Those things didn't happen. Nick Clegg, along with David Cameron, they had a big majority. They wanted to reform the House of Lords. That didn't happen. There are more checks than people realise. One of the problems is that politicians buy this myth, and they arrive sometimes in Downing Street. I think Theresa May fell for this too. She was a fundamentally majoritarian politician. She thought she could somehow bash her Brexit deal through, and the House of Commons would have to accept it. And the House of Commons, including the people that I mentioned before, hit back and said, no, we won't actually. So, it's a dangerous myth, this idea of absolute executive control. And if you buy into it too much as a politician, it can come and bite you on the bum.
I think unless any of our other panelists have any further thoughts on that, that might be a sobering thought to wrap up on. And so I suppose I'd like to wrap up and end this panel by thanking all of our speakers who've very graciously and generously given their time on a really hot Tuesday afternoon and evening to discuss the finer points of Britain's constitution with us all. And so I hope you're happy to make do with a virtual round of applause. It's not quite the same on Zoom, really, is it? But once again, thank you all so much for giving your time and answering all our questions, and we very much appreciate it. And I'll do one last plug for the other events which are taking place as part of the Young Lawyers Making Change Festival. If you have found any of today's panel discussion interesting, I really recommend you attend tomorrow's panel chaired by our wonderful colleague Siobhan Taylor-Ward on When the Law Runs Out, Campaigning for Social Justice, where we'll be discussing campaigning in more detail. But once again, a huge thank you to all our speakers, and a thank you to everyone in the audience for joining us today. Thank you and goodbye.